Hi, this is Jeffrey Warnick. Welcome to podchute. I'm happy to have as my guest Clark Neily. I'm just meeting Clark for the first time, but I had gotten to know Clark a little bit by his the book that he wrote, I guess about 10 years ago, Terms of Engagement, How Our Courts Should Enforce the Constitution's Promise of Limited Government. I guess the Supreme Court or none of the courts probably have not read the book yet, so they probably should. They definitely should, in my opinion. Clark currently is at the Cato Institute, Senior Vice President for the Legal Studies. Prior to the Cato Institute, Clark did litigation work at the Institute for Justice, and Clark is also teaching some classes at the George Mason University Law School. Before we get into the topic about the weaponization of Department of Justice, how was it to do the move from moving out of litigation into a think tank? I would think this litigation would be really fun and interesting because you can really impact. I don't know which is more impactful for public policy, the litigation route or the ideas route at a think tank.
Yeah, definitely two different settings, and I enjoy aspects of both. Litigation can be, very intense and exhilarating. The one way to put it though would be it's like asking somebody who is a mountain climber, who has given it up for some other sport, do you miss climbing mountains? And the answer would be, well, yeah, I absolutely miss being on the mountain, but do I miss dragging 4,000 pounds of equipment through scorching deserts and glaciers, freezing glaciers just to get to the mountain? No. And most of modern litigation is discovery. It's corresponding with opposing counsel, and really has very little to do with what most people think, being in court and being a courtroom lawyer involves. And you're almost never in court. You're lucky to even get a couple of court arguments per year. Whereas in a think tank, I would say, a lot of what's kind of miserable about litigation is just absent. You're not exchanging nasty emails with opposing counsel. You're not digging through boxes and boxes and terabytes of data just to produce some obscure documentation. You get to go right to the heart of whatever the problem is. Now, granted, you don't do that in a litigation setting where you're squaring off with all the drama and the excitement, but we still have a pretty good time.
Okay, great. So let's get into the topic of when people. A lot of people have talked about the weaponization of justice, the weaponization of government, and if you ask different people what that really means and who's weaponizing what against whom, there'll probably be very different definitions and different perceptions regarding what the terms mean and how to apply it. So when is there the words I like to use is how to distinguish the difference between the prosecution of the law versus persecution by law. So at what point, and that could be very subtle, the differences between when people are really prosecuting law or persecuting through the use of the law. So so first, before as we enter this conversation about the weaponization of the Department of Justice and maybe government in general, maybe we should be talking about the weaponization of the Supreme Court and the shadow docket. So maybe we could explain, who is weaponizing the law against whom to be, a broader conversation. So why don't you? I'll just make one other comment before I turn it over to you. I had the opportunity to know, not very well, Aaron Swartz. I don't know if you know the circumstances by Aaron Swartz.
Yes.
Who was a real hero in my book. I think that's a textbook example that's not spoken about enough about, how the government has weaponized law against an individual, probably to represent a special interest group that where Aaron Swartz was inconvenient for them getting. That was about the legislation with respect to, I think it was called SOPA, with respect to the a lot of content creators deciding that they didn't really like YouTube, believing they were ripping off people's content, and wanted to have the president to have extreme powers to just shut things down.
I should probably jump in at some point, Jeff.
Go ahead. Sorry. Let me shut up. Go ahead.
So I think that some people would resist the idea that it's possible to weaponize the law or weaponize the Department of Justice, and they would demand, some kind of an objective definition that, you could fall into some sort of a no true Scotsman situation where they'll never be satisfied that you've established that it can be done. But I agree with you. I think it's very clear that, in fact, the law and specific agencies like the Department of Justice can fairly be said to have been weaponized in certain settings. I would say there's kind of, maybe we could think about it as being three boxes. Box number one would be exactly what you would expect and want from an ethical, well-functioning Department of Justice. And that would be an organization that makes an effort to find people like Bernie Madoff, who are defrauding investors through, illegal Ponzi scheme and ripping off, widows and charitable organizations by enticing them to invest, knowing that he's running a fraudulent scheme, or transnational terrorist organizations that are victimizing American citizens in various ways. You would want a Department of Justice to vigorously investigate and prosecute people involved in that. Another example that's rampant in this country would be various forms of fraud against the federal government, submitting false claims in Medicare, for example, for work that was never done, and siphoning off resources into organized crime or crooked doctors that should be going to support genuine medical care. All of those things happen. They are investigated, they are prosecuted, and they ought to be. And that would be the activity in box one of a well-functioning, non-weaponized justice system. At the other end of the spectrum, the worst end of the spectrum, is what I think we're seeing now with the Trump administration, at least in some cases, which is a clearly weaponized Department of Justice. And I would say that the clearest hallmark of a weaponized Department of Justice is when the leadership, and that could mean the Attorney General, the president, or even lower level officials, decide that they are going to find some way to prosecute a particular individual because of what that individual has done politically or personally to the leadership. And Trump, had that. There was the Truth Social post that we now know he intended as a private message to Pam Bondi, the Attorney General, where he urged her to prosecute specific former Biden administration officials, James Comey, John Brennan, I think also Letitia James, who was the Attorney General of New York, who went after Donald Trump in a civil fraud case. And so he specifically identified these individuals and essentially said to the Attorney General, I think that, you're being insufficiently diligent and kind of embarrassing your department by not already bringing prosecutions. And so in Trump's view, what was important was not so much whatever conduct they engaged in, but that he felt that because of various activities and conduct that they had participated in that were sort of harmful or antithetical to Trump's interest, they should be prosecuted. And then what began was a process. Okay, let's see what we can figure out to prosecute them for. And I would say that just about anybody who has worked at a high enough level in the government or run for office or run a sufficiently complex business, or frankly, just had a very interesting life, has probably committed some crime, and perhaps even a felony, perhaps even a federal felony, for which they could, in theory, be prosecuted. I think there are not that many people that you could put their entire life under a microscope and not find anything for which they could be prosecuted criminally. And I think it's pretty clear that's what's happening in those cases with respect to those individuals. And then the last point I would make is that there's a box in the middle where you might call it weaponization, you might not, but it involves very dubious assertions of prosecutorial power, whether the choice to prosecute at all or the way in which the prosecution is handled. And I think that you identify a great case. Just for those who don't know, Aaron Swartz was an internet genius. He helped invent Reddit when he was still a teenager. He was a graduate student at Harvard and felt that it was unfair and just contrary to his values that this academic database called JSTOR would not make freely available to the public all of the academic papers that were behind JSTOR's firewall. So Aaron Swartz created a computer program to essentially download the entire JSTOR database. He hooked that up to MIT's computer system, and it worked. He downloaded a lot of the content from JSTOR, made it available to the public. Long story short, he was prosecuted for computer crimes by the federal government. When they got done charging him, he was looking at a 13-count felony indictment that exposed him to 35 years in prison and about a $1 or $1.5 million fine. He was offered a 6-month plea if he would agree to plead guilty to felony computer fraud. They would arrange for him to have only a 6-month prison sentence. He was threatened with 35 years. And we don't know how that story would have turned out because unfortunately Aaron Swartz took his own life because the pressure of that the government had brought to bear in terms of what it was threatening versus what it was offering was more than he could take. And it was a real tragedy. And I think an absolutely despicable example of prosecutorial abuse. But as the U.S. attorney for the Boston U.S. Attorney's Office, Carmen Ortiz, correctly said, it was absolutely the way the Department of Justice does business day in and day out. So that kind of coercive pressure to induce a guilty plea, to induce somebody to waive their right to a trial and simply plead guilty whether they did it or not, is absolutely the bread and butter of every federal prosecutor and every state and local prosecutor. It is the way our system works.
And it's a sad statement that that's the way the system works.
It is.
So the system is designed to weaponize the government. So this is independent. So, I mean, you use the word, the question is why should we have any expectation that the type of person that would be, how do we build the check? You know, we supposedly, I guess, and we have a system as a checks and balances in the system by the fact that people bring prosecutory charges, that we have grand jury system, and then we have a jury system. But, you know, when the government can create for a very simple offense, create a whole series of felony charges that lead into very, very long prison sentences. I mean, right now, if you think about like the Letitia James case, I think for the case of her, I think that from what I've seen, that from what I've read is they say the interest rate differential they think that she allegedly benefited from, over the life of the loan has been about $19,000. You know, so it's about $3,000 a year or $4,000 a year, not much more than that. And they're talking about having her committed to like 13 felony charges where she could face 30 years in jail.
Let's make sure people understand what happened in this case. So when Letitia James applied for a mortgage for a second property, you are asked what you intend to use the property for. And if you say that you're going to use it as a primary residence, then you will get one rate on your mortgage. If you say that you're going to use it, for example, as a rental property to generate income, you'll get a different arrangement. And so like many people, it appears, or at least the allegation is that Letitia James incorrectly stated that she was going to use the residence as, or the property as a residence, as her second home. But then again, according to the indictment, she actually turned around and rented it out to generate income. And as you say, Jeff, the difference in sort of terms that she would have gotten had she said, yes, I'm going to use it as rental property, as opposed to a second residence, appear to be fairly trivial, less than $20,000 over the life of the loan. So I think that's a good example. I think you're right. I think that's a good example of conduct that the Department of Justice would not bother to investigate and not bother to prosecute in most cases, unless they had some ulterior motive, as they obviously do in this case. And the last thing I would say about it is, you know, you asked earlier, like sort of open-endedly, how could we assess the legitimacy or the how defensible a given prosecution might be. I'll give you one really simple heuristic. What would the Department of Justice do to a federal prosecutor who engaged in the same conduct? And the answer in this case is if they caught a federal prosecutor misrepresenting, what they were planning to do with a piece of property on a mortgage application, the answer is they would do nothing. Nothing. And if you can be confident that they would do nothing to one of their own, then to me, that's a decent framework or heuristic for what they should do to some other person who gets caught doing the same thing. And if a prosecutor is going to get a free pass for that conduct, as they almost certainly would have, and they routinely do get a free pass for similar kinds of illegal activity, then people who are not prosecutors should get the same free pass. And that is what normally happens with things like alleged mortgage fraud. They just don't bother to investigate it. They don't bother to prosecute it unless you happen to have done something that aroused the ire of the president, and then they're going to make an exception for you. And I think that's a fair characterization of what's happening here.
Yeah. And that's like, and from what I've read, the other specifics of the Letitia James case is that apparently during most of the period in question, it was a relative of her that was living there, that when she used it as a second residence, she had no obligation to actually be there. So she could say, I have a second residence that she just never visits. So, and she has that right to do that. So no, if I say I have a second residence, the bank can't force me to actually spend time in my second residence. It's just not my primary residence. And I borrowed money and they know it's a secondary place for me to go, but there's no obligation unless a contract stipulates that you have to be there a certain amount of days a year, unless it's a stipulation is there in the contract. Then there was basically no binding obligation for you to actually go visit the place.
Well, I think that's right. But there are further allegations in this case that she actually generated income with the property by renting it out and paid taxes on that income. If she did that, then she has a bigger problem than if she only did the things that you've described.
What I did read is the mortgage contract had a rider that let her do some renting out, just not in the first year. So she did not rent it out the first year. Apparently her rental income was minimal, and that its principal purpose was used as a place for a family member, and she was paying for the upkeep for a family member to stay there in a second residence. So what I read, if it's true, what I read was that there was a rider on the document that did let her do some renting it out, but it's clear that its principal purpose was not as a rental property.
So I don't think we want to litigate the details of this particular case right down to the last, because we really don't know what happened. I'll stipulate to everything that you said. What we want to keep in mind is that the Department of Justice has a very strong track record of obtaining convictions, even in cases where nobody did anything wrong or where the facts are at best murky. And how do they do that? They do that by exerting plea pressure, by threatening people with so much damage if they don't agree to plead guilty that any rational person would agree to plead guilty, whether they were guilty or not, whether they had some strong defenses, as I believe Aaron Swartz did, and probably Letitia James does. And we know this because there is evidence that innocent people are regularly induced to plead guilty to crimes that they did not commit. And so it may be that the prosecutors working on this case are simply assuming, and perhaps perfectly rationally, that it really doesn't matter how strong the case is, because if it's going to go like a normal case for the Department of Justice, they will simply exert however much pressure is necessary to get Letitia James to waive her constitutional right to contest the charges and plead guilty. And I'll give you one more example. Some of you may be familiar with the Varsity Blues investigation from several years ago, where a number of Hollywood celebrities, New York lawyers and bankers, et cetera, were accused of resorting to various dishonest schemes to get their children into colleges that they would not have gotten into on their own merits. They prosecuted 54 people, give or take, and all but 4 of them were induced to plead guilty, including a number of Hollywood celebrities like Felicity Huffman. The way they got people to plead guilty in that case was that the average or the standard plea offer in the Varsity Blues investigation was 2 months. And they were specifically told, the defendants were specifically told, if you don't take that deal, we will go back to the grand jury and get a superseding indictment in which we'll include a charge of conspiracy to commit fraud, for which the maximum punishment is 20 years. So you threaten somebody with 20 years. Now, they're not going to do 20, but they might do 7 or 8. You threaten somebody with either 20 years, or if you look at the sentencing guidelines, maybe 7 or 8 years, and then you give them a 2-month plea offer. And guess what happens? Nearly everybody agrees to plead guilty, whether they are or they are not.
What percentage of these cases actually ends up in court, litigated in court, and what percentage of them end up being, from my understanding of the statistics that I read a while ago, is that actually most of these types of litigations end up being plead out and very few go to court?
We don't have really good statistics in the States just because there's so many cases there and the reporting is not as reliable. But we have very detailed information about the federal system. And what we know is that in the federal system, if we look at what happens after the government has gotten an indictment, in other words, the grand jury has given the approval to pursue the case, and the defendant is indicted, so the formal process is started. What happens at that point is 90% of defendants plead guilty. 8% of cases are dismissed for a variety of reasons, and 2% go to trial. Okay. Of the 2% that go to trial, defendants have what I consider to be a surprisingly high win rate. If we think about the resources that the federal government has, the ability that they have to cherry pick their cases. Really, in theory, they should never lose a case, because they make a big deal of how they never take a case to the grand jury unless they believe that it's airtight. So you would think that the Department of Justice would have something like a 95 or 99% win rate when they take cases to trial, but they actually don't. They only have an 83% win rate in the last year in which I could find statistics. So actually about 17% of defendants who reject the plea pressure and exercise their right to trial end up being vindicated, or at least acquitted of their charges, which, you might not think that's such a great rate, but if you actually look at it in context, given the ability of the Department of Justice to cherry pick cases, to investigate them to the hilt, and of course the resource mismatch between the federal government and the defendants they pursue, I actually think a 17% loss rate is pretty remarkable for the most powerful prosecutorial office in the entire world.
Well, let me ask a question then about the 17%. You might not have this data, probably is not publicly available. Any estimate about how much money that it cost the 17% of the people who were able to obtain an acquittal, on how much money they spent to get an acquittal?
It's a great question. There is not data on that as far as I know, but we did have a federal judge for the Southern District of New York, a very well-respected judge named Jed Rakoff, who was asked that very question at an event at Cato about, I think, 7 years ago. And he said that based on his knowledge from his, I can't remember, 25 or 30 years on the bench, that he believes that the average cost of defending a white-collar prosecution today, or I'm sorry, this would have been in 2018 or 2019, was about $25 million for the defendant.
Okay. So basically what we're saying is that if you don't have a very deep pocket, you're going to plead guilty.
Well, you're going to have representation that is below the standard that you would probably want if you were, wanting to present your best defense, or you'll have to settle for a public defender, which in the federal system, they tend to be quite good. Perhaps not as good as what you could get if you had $25 million to spend, but much better than if you were in any state system. So you're going to get a pretty good lawyer, but you almost certainly won't get the quality representation that you would if you did have the $20 or $25 million to spend on your own counsel. Correct.
So, and we don't know really what that does to, if we take a look at those that, and you might not have this data, it seems like you don't have the data, we wouldn't be able to know what the conviction rate is on those that had to rely upon a public defender versus those that had a huge checkbook, and were able to spend a lot of money to, counter to some extent the government's even deeper pockets.
That is a fascinating question. Maybe I'll make a note to see if I can find any study that has looked at that, but I'd like to know the answer to that too. You know, and it's not just the quality of the lawyers, because the federal public defenders are an excellent quality of lawyer, but it's also just the resources available. You know, complex white collar cases of the kind that the Department of Justice brings tend to involve, you know, astonishing, staggering amounts of data, terabytes of data that has to be organized, evaluated, reviewed, you know, tested, and so forth. You might need investigators to go out and find witnesses and addresses and warehouses where things have been stored. Those investigators, if you're on the government side, they're called FBI agents. They work for the government. They don't have to be paid separately. But if you're a criminal defendant, of course, you'll have to pay for your own investigators out of pocket. And if you need an expert witness, like a forensic accountant, that's going to cost you, you know, $500 or $1,000 an hour. And good luck, you know, trying to pay for all your investigators, all your expert witnesses, all the lawyers and paralegals that it takes to analyze all that data. The burn rate, that's what we call it, the burn rate on a really intense white collar criminal case, when it really gets going, could be, I've actually had friends who've litigated precisely these kinds of cases. And by the time they get to trial, the burn rate on one of these cases can be $50,000 to $100,000 a day.
So yeah, so I guess it's, and you make a very, very good point. It's not just about hiring the lawyer. It's all the resources that the lawyer needs to support their work.
Yep.
And all those resources that the lawyer needs. I mean, the lawyer could do a great job, but at the end of the day, if the lawyer has limited resources, then that's impacting the lawyer's ability to defend you, because the lawyer doesn't have the same resources to access as the government lawyers have.
Can I tell you a quick anecdote that illustrates this point?
Sure.
There's a wonderful criminal defense attorney in Florida named David Marcus, exactly the kind of person you'd want to have if you were involved in the kind of case that we're talking about. And in the podcast, one of the lawyers for John DeLorean, the guy who you know, the car manufacturer for back in the 80s, he was being prosecuted for, you know, standard kind of white collar business conspiracy. The really short version is that he had testified that some important transaction or you know, event in the case had occurred at a particular business office somewhere in Switzerland, and the government put on and he gave the address, and the government put on an FBI agent who showed that an invoice from this company had a certain address on it, and that he personally had gone to that address and determined there was no such location. There was no business at that location. And obviously that's a big problem for John DeLorean. What his lawyers did is they asked the court to order the government to produce every single invoice from this company, which the government had not yet done. And the government tried to resist this. The court said, yeah, that sounds fair, produce them. And so they get this giant stack of invoices. And it turns out that a few of them had a typo. Most of them had a different address than the one that was shown by the FBI agent. And when they hired an investigator, when the defense hired an investigator to go and look at the address that was on most of the invoices, it certainly did exist, and it had the actual logo of that company on the door of the business. So the government had cherry-picked a couple of invoices with typos on them, and then had the FBI go and look at the non-existent address and testify in court that this office doesn't exist, knowing the whole time what they had done. And then the defense managed to, you know, through a significant exertion of effort, discover that the government had cherry-picked those documents with the typo, and that if you had looked at the invoices with the correct address, you would have gone to that address and said, yep, he's right, that company is at that address. That's the kind of thing you have to be on guard about in a trial, for example.
Does the judge have a power in a trial like that, where they know that, I mean, clearly there should be a responsibility for the government, since the government represents the people. Okay, so the goal of the government is to execute justice.
So your question is, does the
win
judge
judgments? So
have the power to do anything about it?
You have exculpatory information, you cherry pick it. To me, that's equivalent of, you know, an act of perjury.
Yeah, and the answer is absolutely, absolutely. You will occasionally see judges give prosecutors a very discernible slap on the wrist when they do something like this. You can almost actually see contact skin to skin in some cases when the judge gives the prosecution a slap on the wrist.
Does the judge have the power to just say, is you cherry pick data? This trial is over. This person is innocent. I'm not letting him trial, but it's because of bad faith on the part of the government. Do judges have the capacity to do that? Do they have the right to do that?
They absolutely do have the capacity to dismiss the case, and you will almost never see them do that. The most you will, almost without exception, the most you'll see a judge do for something this bad is a just barely discernible slap on the wrist.
And in your opinion, would the courts treat the same way? Would most judges treat the same way bad behavior on the part of a prosecution run by the government, as opposed to the behavior of somebody who was not part of the government behaving in exactly the same type of behavior?
Oh, no.
Would they be symmetry?
Not only if I behaved like that as a private lawyer, not only would my case be dismissed, I would be disbarred. So yeah, there's absolutely a double standard for prosecutors versus non-prosecutors in when it comes to the consequences of getting caught committing blatant misconduct. Massive double standard.
So basically what you're describing here so far is a system where the odds are stacked against the people and to the benefit of the government. We have a legal system, it seems to be, where we create penalties associated with certain crimes that seem to, you're shaking your head no, so maybe.
No, I have to just gently correct the phrasing. First,
Okay,
you use the passive voice, and then you said we created. Neither of those things, I think, conveys the accurate picture, which is prosecutors have hacked the system with the basically with the complicity of judges, a wildly disproportionate number of whom used to be prosecutors themselves, and we've documented that, so that the rules no longer apply even-handedly. They do on paper, but they don't in real life. So I want to just make clear, we did not do this, and it wasn't done through some, sort of passive, inevitable dynamic. Prosecutors and judges have altered the system in such a way that there is a double standard for prosecutors and other government agents, and defendants are put at a substantial disadvantage compared to the nature of the playing field that should exist if all of the applicable rules, including constitutional rights, were being fully and fairly enforced. So to be clear, yes, there is a wildly unlevel playing field and an indefensible double standard, but it did not come about by accident or through the operation of some, organic dynamic. It was done by prosecutors with the complicity of judges, and it's really important that people understand that.
Yeah, well, you just said that because that was the point I was going. When I said we, I meant as a country. So I meant as a country, we've implemented a system. And that is to the detriment of the people, that we've given the government an edge over the people. So we're giving the government the ability to have significant leverage every time they sit down in a room with this private citizen, that the whole system is designed for the benefit of the government to the detriment of the citizen. Okay.
Yes, I agree with that.
Which is very contrary to really what the principles of our founding documents.
Yeah, no question. And I want to make clear to people that at least I believe, and I've been working in this system in various capacities for pretty much my entire professional career. And what I think is important for people to understand is two things. First, in every single setting where citizens square off against the government about the scope and or application of government power, and it can be anywhere from something as low stakes as a traffic ticket, as contesting a traffic ticket, all the way up to a death penalty case or a multi-billion-dollar antitrust action brought by the Department of Justice, and everything in between. In every single one of those settings, the playing field is supposed to be either strictly level or somewhat tilted in favor of the citizen, as in a criminal prosecution where the defendant enjoys a number of rights that the government doesn't have. Just to take one example, that there is no double jeopardy. That means that even if the government loses a criminal prosecution, so the defendant is acquitted, and there was a glaring error that went in the defendant's favor, like the court erroneously excluded some important piece of evidence that the government should have been allowed to present, and the acquittal was clearly mistaken, the government still cannot bring a second prosecution, and they cannot appeal the verdict. They're stuck. That acquittal stays. So in every single setting where the government squares off against individuals, the playing field is supposed to be either strictly level or slightly tilted in favor of the citizen. By contrast, in reality, in every single setting, every single adjudicative setting where the government squares off against citizens, the government has hacked the system so that the playing field is persistently unlevel in favor of the government. And that goes all the way from something as trivial as contesting a traffic ticket all the way up to trying to defend a multi-billion-dollar white-collar criminal prosecution or antitrust action or some other commercial case against the government. You will never find yourself on a truly level playing field with the government in any adjudicative forum. The playing field is supposed to be at least even, and you will never see an even playing field in your entire life if you square off against the government in court. And I will say that was absolute confidence. And I think that is a disgrace and an affront and a betrayal of the very concept of due process. But that is absolutely the system we have.
Do you think a honest judge, a decent judge, when the president, without really having all the facts, without the other party being able to present their side of the story, declares somebody guilty, and goes and cherry picks the jurisdiction under which they're going to try that person? Is that person really capable of having a fair trial?
It's a great question, and I know the answer you're looking for is not, and my instinct is to say probably not, but I would want to say we have to actually break it down into its component parts and ask whether each of the things that you described as happening, did the judge rule consistent with the law or not? So there are various ways in which prosecutors can seek advantages that are legitimate. There may be more than one jurisdiction where that case could be brought. And if they exercise their charging discretion or some other power that they have in order to be in one jurisdiction as opposed to another that they perceive to be more favorable, that may be getting an advantage, but it's not an illegitimate advantage. By contrast, there are other things that government lawyers can do to seek advantage that are illegitimate. And a perfect example that happens all the time is withholding evidence, materially favorable evidence. So there is a constitutional obligation that prosecutors have to disclose evidence in the possession of the government that is materially favorable to the defense, either because it's evidence of innocence, or because it's evidence that would help to undercut the credibility of a government witness, or evidence that would incline the judge to a lesser sentence, anything like that. It is routine for prosecutors to fail to turn over evidence that they have an obligation to produce to the defense. That material is called Brady material from a 1970 case called Brady. And that is a persistent feature of our system, is prosecutors seeking an illegitimate advantage by failing to turn over materially favorable evidence. And that's another example where pretty much no matter how bad that misconduct is, the most you're ever going to see is a prosecutor get a slap on the wrist. And sometimes you won't even see that.
Now, going back to one of the things that you said that was something that many lay people might not understand, is that when you're preparing for a trial and you're in the litigation business, that very little of the time is in the court, right, and most of the time is out of the court, and most of the time out of the court is associated with the process called discovery. And for me, as someone who has taken some courses in the law school when I was at the University of Chicago, even though I studied finance and economics, I did take courses in the law school. I was always been very fascinated with the law since it's the infrastructure of the society. So, but as an economist, the way I kind of look at a discovery process is that when you want, given the fact that we have basically a system of, on the most part, that is a trial by jury and jury of our peers, that we don't want cases decided based upon there being any information asymmetry. So whatever information that is available should be made presentable to the jury as long as it complies with the laws of evidence and the procedures associated with how that information was obtained. We don't want somebody being able to tilt the playing field by withholding any evidence that would impair the judgment of the jury coming up with a good choice, with the best solution they can based upon playing game with the information that's submitted. So anything that should be relevant should be presented in discovery, and that way the jury can make an informed judgment rather than a judgment predicated upon propaganda or information asymmetries.
So I agree with everything you said, except for one thing I would alter a little bit is you said the word jury about 7 or 8 times, and that could give people a misimpression that juries are routinely involved in deciding disputes in this country, including disputes between citizens and the government, and juries, and they're supposed to. There's one of the most important features of the Constitution, and that the founders of this country considered more important, arguably even than voting in elections, is having disputes, and especially disputes between citizens and government, decided by juries, which is to say ordinary citizens. That is arguably one of the most central designs of the Constitution and one of its most genius features. And juries, both civil and criminal, are instead practically extinct on American soil. They have almost nothing to do with the administration of criminal justice and very little to do with the resolution of civil disputes anymore. They're supposed to, but they don't. And there's a variety of reasons for that. But when it comes to disputes between citizens and the government, the main reason that juries have almost nothing to do with that anymore, even though they're supposed to be central to it, is because the government would prefer to have cases against it decided by its own employees. And who are those? Judges.
Yes. So I have, I think you've done a really excellent job of describing, how unreasonable our system is not weaponized to really dole out justice. So because anybody interested in justice would not have a system where there basically is the disparity of power. Once you have a disparity of power, you don't have a just system. Unless there's a level playing field, you're not going to get justice. And what you have described is not a level playing field. It's a very tilted playing field.
Right.
And we never expect a tilting playing field to produce a just outcome.
Could I clarify 2 points?
Sure, go ahead. Clarify everything you want to clarify.
So I think that's directionally correct, but in order to be, rigidly honest, let's think something a little more clear. It's not that you will never get justice. You may in fact get justice. It just is not statistically likely. So as an economist, I'm sure you can appreciate my point, which is that you will see some cases that come out correctly, notwithstanding the persistently unlevel playing field. But in the entire scheme of things, the government will win more cases than it should, even though some people will in fact get a just outcome, notwithstanding all of the illegitimate disadvantages that they confront. So that's point one to be clear about. The other point to be clear about is it's not necessarily the case that all disparities in power bring with them a massive distortion in outcomes. It's specifically the difference in official power. It's when ordinary citizens square off against the government. Now, are you at a disadvantage as an ordinary citizen squaring off against some big company? Yes. In most cases, yes. But I would say that it's not as pronounced a disadvantage, and it's not as persistent a disadvantage as when the citizen is squaring off against the government, where the system, the adjudicative system, has been even more thoroughly and completely hacked, if that makes sense.
Yes. So given the fact that it's hacked to their benefit, to the people's detriment, okay, what can we do? Okay, like I will say that one of the things I've talked about recently regularly on I have a regular Monday podcast with Bruce Fine. I don't know if you know of Bruce Fine or know Bruce Fine. And one of the things I advocate for is that I think more grand juries should practice nullification when they think the government, is basically applying its unfair advantage to the detriment of people. And maybe a grand jury should know, and they should be conscious of the fact that once they decide to do an indictment, they're putting somebody into a system that's kind of rigged against the people, and and maybe many people who serve on grand juries don't have the knowledge of, the consequences of really what the person that they are saying they're recommending should be indicted for, what they will confront.
So do you want me to answer?
Once they decide to approve charges against that individual. Go ahead.
So that would be great. It will never happen. Grand juries are basically irrelevant because they have been so captured by prosecutors. We can fantasize about grand juries doing that job, but they won't. Without some, I would say, unrealistically massive change to the system. So it's not where I would look. You're absolutely right that it should function that way, but it won't, and it never will. So I would look for more realistic changes.
Okay.
The first one that is entirely within our grasp would be to ask a very simple question, and that is, if we were populating a federal judiciary from scratch, would you think that it would be optimal to have a federal judiciary in which prosecutors and other former courtroom advocates for government wildly outnumbered and were vastly disproportionately represented as compared to people like me who spent most of their career challenging the government in court? Or would you want those two populations to be roughly equal? And it seems to me the answer to that question is quite obvious. If you have an institution who has as one of its most important duties to limit government power and properly adjudicate cases involving the government as a litigant, I think you probably would not want a judiciary in which former courtroom advocates for government are wildly overrepresented. But that's the system we have. It's not, in my judgment, the system anybody would choose if they were starting from scratch. And so we should do everything that we can to move in the direction of a judiciary in which former courtroom advocates for government are roughly equal in number to former courtroom opponents of government. Because the judiciary is an intellectual ecosystem. And like any other ecosystem, you don't want it to see it wildly imbalanced in favor of any particular population if that population matters to the well-functioning of that ecosystem. Does that make sense?
It makes sense. How do you get people to agree to that?
Well, you would have to have a sufficient buy-in from whoever is president, because that's who nominates judges. And then also the Senate, and specifically the Senate Judiciary Committee. So it's a fairly limited number of people. And hopefully, if you were able to explain to those people, and I think the most important people here would be the president and whatever number of senators on Senate Judiciary Committee were necessary to get the nomination out of committee. And that's probably 8 or 9 people.
How many presidents do you think you could convince of that?
Fair question, and I will volley at the net and say more than 6 months ago.
Do you think Trump could be convinced of that?
No.
Okay.
Not because, and by the way, not because he wouldn't be amenable. I just don't think that he has the intellectual horsepower to understand the argument that we've made so far. I think he would have tuned out by now and be watching Fox News.
Yeah, but that system would not let him go after the people he wants to go after. So
right, but that system would have probably done it. Like, it probably would have saved him from some of the litigation that he got. No, who knows? I would say Donald Trump probably just doesn't have the intellectual horsepower to really even think through the argument of whether he, in particular, would be better off with one particular composition of judiciary or the other. I think 4 words into that sentence, it might as well be Greek to him.
Yeah. So what are you and the Cato Institute trying to do with respect to leveling the playing field and having a system where government is not so weaponized against the citizen, and having more of a system as envisioned by Thomas Jefferson, where the citizen is weaponized against the state, but the citizen has no fear of the state.
Right.
So
let me set the stage by saying this is a bit like asking a doctor, what are you doing about that patient's very aggressive stage 4 cancer?
Yes.
Right. And the answer is everything that we can think of that might actually help. So that is, and I'm not really doing a bit here. I would say that the current state of our criminal justice system in particular can fairly be analogized to a very aggressive metastasizing stage 4 cancer. You do not treat it with antibiotics, which is what most people in criminal justice reform are trying to do. And you have to reconcile yourself to the fact that you are going to have to use something extremely aggressive and outside the box, something the equivalent of a very exotic form of chemotherapy in order to address the problem, because anything else you throw at it will not make a dent. So we're doing a couple of things at Cato. And I'll share with you, I have a framework, a heuristic, an analytical method of assessing the probable efficacy of any given criminal justice reform, and I can give it to you in about 10 seconds. What you do is you describe what you're proposing to do to a prosecutor. If they like it, it's garbage, and you abandon it. If the prosecutor only mildly objects to it, it's a waste of time, and you shouldn't work on it. If the prosecutor's hair lights on fire spontaneously and they jump out of their skin, you are probably onto something, and it deserves a closer look. There is one thing that I have found terrifies more prosecutors more deeply than anything else that I have ever seen put in front of them in the 10 years that I've been doing criminal justice reform. And that is the prospect of having to try their cases in front of a jury that has been given an accurate understanding of its true role in the process. There are basically two ways of looking at the role of a jury in adjudicating a criminal case. One is the correct way, and the way that the founding generation looked at juries, which is that they are not just in court to listen to the evidence and find facts and then rather robotically apply whatever law the judge gives them. That's the modern view of a criminal jury. What founding era juries were primarily charged with doing is preventing injustice. Now, that might be by preventing a factually baseless conviction, but it could also be by preventing a conviction in a nakedly political case, or a conviction on the basis of a law that shouldn't even be on the books, like the Fugitive Slave Act, which produced plenty of jury nullification, so-called, back in the day. So that was the understanding of a criminal jury up until about the mid-1800s. And then as the institution of jury service became more democratized, it began to include women and people of color, et cetera. The role of the jury was transformed by who? By judges and prosecutors, to its modern understanding, which is that criminal jurors are basically like a bunch of trained circus seals. They're just there to listen to the evidence and then basically robotically apply whatever law is given to them by the judge. And they are falsely told that that is their only legitimate role. Absolutely untrue. But that's what they'll be told by the judge. Some cases, they'll even try to make them swear an oath that they won't do anything else, even though there's no legally valid basis for that oath. And jurors will be misled into believing that they have no power to acquit a factually guilty defendant against the evidence in order to avoid an unjust conviction, when in fact they do have that power. And anybody who expresses any understanding of anything I just said will be excluded from jury service. Why? Because they have too accurate an understanding. They have an excessively accurate understanding of their true role, and that means they won't be permitted to serve on a jury. So we could change that, and we should. Now, you could try to get judges to change it, but they won't. So another way to do it is to pull out the stops and do everything you can to make sure that every single person who is eligible for a jury service in a given jurisdiction has heard a very compelling presentation of the facts that I just gave you. And we're working on precisely that public education campaign right now.
Yeah, and I'm happy to be part of that, having this interview with you and giving you the opportunity of explaining this to the people watching this podcast.
Thank you.
That we will actively promote. This is why I do it, is to give a platform for people like you who really who believe in the vision of the founding generation of a limited government, and it was the principal role of the government is to let people live free, independent of government, as sovereign individuals. You know, expression I kind of use is like the what I thought was the revolutionary concept of the founding of the United States, is that we were creating less a sovereign nation and more a nation of sovereign individuals. So that's kind of like how I describe the difference, because basically prior to that, people were not citizens and sovereign individuals. They were subjects, and they were subjects to a monarchical state or some sort of despotic tyrannical state, whether it was a monarch or a tsar or whatever it was called. Instead, we decided to have a representative form of government where ultimately the individual was sovereign, and the job of the government was to protect the sovereignty of the individual, not to govern over the individual. So the philosophical framework of our document was so different than any other document pre-existing in thousands of years, and that to me was the real revolution of our founding documents.
Yeah, no, I completely agree. I just want to, I hope I don't sound like I'm beating a dead horse, but I want to add one thing.
Go ahead.
It matters tremendously how you go about implementing that vision, because it will not self-implement. In fact, governments, the founders knew that governments tend to try to claw back that sovereignty for themselves. And I would say that the single most important feature of the system they designed was that the allocation of power between the government and people was to be adjudicated in individual cases, not by the government itself and not by the government's own judges, but by ordinary citizens deciding the outcome of those cases while sitting together as a jury. That was arguably one of the single most important implementation designs of the entire Constitution, and we have simply ripped out that beating heart of how to implement individual sovereignty to where citizens play almost no role whatsoever in the adjudication of disputes with government or the administration of criminal justice. And I defy anybody to identify a bigger disaster in the history of constitutional governance in this country, because citizens play almost no role in the administration of justice in this country anymore. And they were supposed to play a central role. And the founders would be spinning in their graves if they had known what we did with the jury system that they so painstakingly wrote into the very DNA of the Constitution.
Excellent said. Very, very well said. This year should be a special year for us because we're celebrating the 250th anniversary of the year that's coming up, I should say 2026, of the signing of the Declaration of Independence, and we're supposedly celebrating our separation and our independence. I think it's important, like voices like yours, like the Cato, get heard by many, many more people, because if we're going to celebrate the founding of our country, we should celebrate the founding principles of our country, not just the act of the founding of the country. And we should use it as a year of educating the people on really what was that founding vision. If we want to honor that founding vision, we should honor that founding vision by living according to the precepts of that founding vision. And if we want to alter that founding vision, there's only one legitimate way of doing that, and that's by a constitutional amendment. So instead, I think you use a great word, is hacking. We've had the system hacked by politicians. We've had it hacked by people from all branches of government, and where the rules are basically, they've stacked the rules so much against us that they've made it difficult for us to unhack a system, that they've so successfully hacked to increase the disparity between the citizen, and the state, because in my opinion, they only want us to be obedient and pay taxes. So to fund whatever they do with as little interference in whatever they do. So
if I may, I'll say two things. You're absolutely right about the importance of the Declaration of Independence and celebrating the 250th anniversary. I'll go one further and say this. I would say that the signing of the Declaration of Independence is one of the most important events in all of human history, because it helped. It essentially represented the beginning of the first nation that was really designed from scratch to honor the principles that you have just described of individual sovereignty and the idea that all men are created equal and possess certain unalienable rights that the government may not legitimately violate. And the next thing I'll say is I don't want people to be depressed by this conversation, but instead to remember that it is no small thing that we have as our political legacy the greatest secular document ever written in the history of humanity, which is the US Constitution. That document contains all we need to have the system that you just described. We simply have to figure out how to go back to being faithful to it. I think we can get there. It's a long journey from where we are now, but we would be lost if we didn't have the Constitution as that guiding star. But thank goodness we do, and all we have to do is to find the wherewithal to get back to it. But we're not lost in the wilderness. We know exactly where we need to be. The challenge is simply for us to have the commitment and the dedication to get there.
Yeah, one of the arguments, Clark, that I've made in our Monday panels that we have with Bruce is I insist, and I guess this is not, I'm not a lawyer, so, but it seems to make logical sense to me. The way I look at the Constitution, it's an ecosystem. What was the objective function of the Constitution? They designed an ecosystem to preserve our inalienable rights,
Yep.
to preserve us as sovereign individuals, and to make sure that the government never had the power to endanger our inalienable rights and our personal sovereignty. So that the government was supposed to set up to solve a limited amount of what I call collective action problems. There's a small set of collective action problems that we need to solve as a society, and the government should solve those small set and do nothing else. Okay, yep. and that, in my opinion, was the original vision. So now, when I see today, and I see Congress delegating power to the executive, okay, to me, Congress delegating something that the Constitution delegated to them, I don't see that they should have the right to delegate something, because the whole point of the delegation of that to them was to preserve the systems of checks and balances to make sure our liberty was preserved. So once they alter through congressional acts, that basically altering the document, because the whole reason why these checks and balances were established the way they were was to prevent tyranny. So so that's a modification of the Constitution, okay? And that should be, to me, viewed as a modification of the Constitution, because there was a reason why certain things were delegated to Congress and certain things delegated to the executive branch. And that, again, is to preserve the systems of checks and balances, so the government could never convert into a government of tyranny. And the founders wanted to make sure, to the best extent they possibly could, that we would never morph into a state of tyranny.
So I really appreciate your metaphor of an ecosystem, and of course it echoes the one I use for the judiciary. I'll put just a slight twist on it, if I may. If you have a flock of sheep, and it's vitally important, to make sure that those sheep are, healthy and survive, because you need their wool and so forth, you would be very foolish if you had no means of protecting them from predators. You would be very wise if you brought in, let's say, an Alsatian. I have a friend who has an Alsatian. They're wonderful, sheepdogs, and they'll stand up to just about any predator. And that Alsatian will do a pretty good job of protecting your sheep. You would be extremely foolish to bring in a timber wolf. That timber wolf will absolutely be capable of protecting the sheep against any other predator. But what it will spend most of its time doing is predating your sheep. And I would say that's a fair analogy to what we've allowed to happen with government. The government was supposed to be just big enough to protect us from foreign powers and to ensure that we are able to exercise the various freedoms that enable us to go on and have a meaningful life. The freedom to who to interact with, who to transact with, freedom from criminal victimization, etc. And that was the government as a kind of an Alsatian, doing just the right amount of protecting, but not menacing. What we've allowed the government to do is to morph into the timber wolf. It's still pretty good at protecting us, for example, from foreign threats. It's not so good at protecting us from criminal victimization. Actually, the police are astonishingly ineffective at that these days. But the main concern about what was happening with government is that it has become so powerful, so self-interested, and so unaccountable that it is much more like a timber wolf guarding a flock of sheep than a sheepdog or an Alsatian. And that is something that we should all be deeply concerned about, because that metaphor is not an exaggeration whatsoever.
Excellent metaphor. And thank you for for sharing it. So what more, for everyone watching, what more can we do as individuals and what do you think will really work from, the kid? Are there any, do you have any allies at all in the House and the Senate? Who are the other intellectual thought leaders involved in really working to convey this message? I think that what I really respect about what you're doing, and that I think takes a lot of courage, is I've seen some people who I've read their books that have described themselves as somewhat sort of public meaning originalists and original intent and limited government, somewhat libertarian. But then I see some of these people, when I see them write editorials and stuff like that, I end up thinking what they're really doing is auditioning for a Supreme Court position or something like that. So, so they might have some underlying philosophy, but basically, maybe they want to be popular on social media, or I mean.
So you asked me, what can we do? Shall I answer that?
What can we do? Yes.
Yeah. So you have to be realistic about the environment that you're operating in. Congress is really not a place where pure libertarians flourish. And that's probably the reason why Justin Amash, for example, is no longer in Congress. Senator Jeff Flake from Arizona left, in the beginning of the first Trump administration. Rand Paul is still there, but he still has to make significant concessions. He's a very valuable voice on many issues, of course. So I would say that our relationship with members of Congress tends to be centered around particular issues as opposed to particular personalities. And yeah, we have a wonderful government affairs department. We work very closely with members of the House and the Senate on an issue by issue basis. There are some, of course, that we are more philosophically aligned with than others, but there really aren't very many people in public life who maintain, a consistent commitment to libertarian principles across the board. And perhaps we have the luxury of doing that at the Cato Institute because we don't have to run for office. We don't have constituents who are constantly coming to us with their hand out, wanting, some particular accommodation. But I think that if you're asking what people can do to try to hasten the process of finding our way back to constitutionally limited government, there are many things that you can do, but I think the most important thing you can do is to find a small handful of organizations that are doing the most effective and ideologically coherent and consistent work on these issues. I happen to think that the Cato Institute is at the very top of that group, but there are many others as well that are working in various spaces. But what is most important, I think, is that we build a solid foundation, or I think a more accurate way to say it would be that we rebuild a solid intellectual, ideological, and political foundation upon which we can then construct or reconstruct the scaffolding of a limited government society. Dial back the massive public welfare programs that are bankrupting this country. Get the government out of healthcare, education, and other and agriculture and all these other areas where it's not supposed to be in the first place, and it's done a terrible job. And so that's not something that's going to happen overnight. But as we build the base, as we build the intellectual framework, and I keep saying rebuild, I mean to say rebuild, and then reconstruct better policies on top of that. If we have the patience and the commitment, we are already making discernible progress, and we just need to continue being focused and understanding that this is not something that we are likely to benefit from ourselves, but it may be that we can get it there for our grandkids and our great-grandkids. And that would be something it doesn't have to benefit you or me in order to be worth pursuing. I will do what I'll give my last breath if I think that I can make the world a freer place for my grandkids, and I think that I might be able to do that.
Well, I think you and I are very much aligned on that. That's why I do what I'm doing. Is that's my only objective. I've had the fortune to having good success in business in my life, so I can basically live my life on my own terms, and basically I can leave my kids enough money to live their life on their terms, but that's not sufficient for me. I want my legacy to be, and when my children, my grandchildren talk about me, I don't want them to talk about, how much money Jeff left me. I want them to talk about is how much effort did Jeff put into trying to protect the founding philosophy of this country that was, as you talked about, was so unique in its foundational principles, and that I will continue doing this till I go to my grave. That this is whether I just can't. This is a fight. As Ronald Reagan used to say, to preserve liberty is very fragile, and to preserve it requires a lot of effort and energy. And I can't think of outside of putting enough food on your table, so you can enjoy, whatever material benefits that you think you need to live a reasonably comfortable life. I can't think of any better use of someone's time than fighting for preserving liberty and freedom. I'm not sitting in front of a TV watching a football game or anything like that. There's no other activity to me that's more important in whatever time I can have. I could devote to not having to, make a living. Is this is my passion, and this is how I will devote the remaining years of my life.
Well, I respect and admire that, and I really appreciate the opportunity to be on your show and all that you do for liberty and limited government. And we're birds of a feather. I've devoted my entire professional life to challenging the government, first in court and now in the policy space. And I hope that between your efforts and mine and those of your listeners and all of our fellow citizens who understand that this country was birthed in freedom, and that liberty is the guiding principle not only of our Constitution, but of our entire society, that the world will be, or America will be, a discernibly freer place for our grandkids and hopefully for their grandkids. And if that's, we may not be around to know, but if that ends up being part of our legacy, then you and I will have both be able to say that we had a life well spent.
Yeah. One of the things I would like to talk to you and on another time offline is, I really want to figure out what people like you, myself, Bruce Fine, and a whole bunch of other individuals, what we can do, that I would throw some money behind to have a messaging, to have a real educational project for the people in this 250th anniversary. Okay. I don't want the conversation with you. That would be great. I don't want the messaging controlled by Donald Trump or anybody in Washington, right, whether it's Trump or anyone else. Okay. I want some people who really think the way we think to sit back and say is, how can we use this anniversary year? What are the distribution channels that we can produce content, and distribute it, of course, all, as many distribution channels as we can, content to really talk about and remind people, what was the meaning of that founding document? What was so unique and special about the founding document? Remind people of the grievances embedded in the founding document, and to find out that a lot of the grievances they had then, we have today, and to talk about the process that we went from the Articles of Confederation to the Constitution. And that ultimately, that one of the things that they constantly had in the concern was, how do we create a nation of sovereign individuals, people who would never be subject to tyranny again the rest of their lives, and the rest of the lives of the Confederation, of the nation, of the Union, whatever term people want to cause that. But I want to make this my own crusade, and I would hope that I could get people to join me in the crusade, to not make it about me, but to make it about I don't care about credit or anything like that. I just want to get this into the public, and really, because this is messaging that's not going to appear on Fox, it's not going to appear on CNN, not going to appear whether the partisan channels. Because this is a message that you don't see promoted in really mainstream media. So so I think about, and we can have a conversation offline on that. So what are the things that you would like me have asked you that I didn't ask you, or remaining comments that you wanted to say, that because I spoke so much, I did give you the opportunity of you getting all the points of point you wanted to get, while you have everybody in front of you who will watch this.
Well, I appreciate that. There's so much that one could say, but I'll try to maybe just hit a few things. So I think one of the most important dynamics of the last few years that gives me a real sense of optimism and reassurance is the number of people taking their children out of the public school system. I think that the public schools are no longer a reliable institution for inculcating the values that you and I have been talking about today. Some of them are just ineffective. Others are actually, I think, actively antithetical to those values. And it's becoming easier and easier and the number of options that parents have to educate their children in a setting that is not only congenial to the values of liberty and limited government, but also more effective at educating, the next generation is growing. And so I think that's a real positive sign. I think the arguably the single greatest risk to the future of the American experiment is our inability to find a way to live within our means. We have become addicted to spending the money of future generations by borrowing from our children and grandchildren and finding endless creative ways to put off the day when that bill comes due. And I'm not an economist. I'm not a finance person. But as a citizen, as a lover of the United States, that is one of the things that keeps me up at night the most, is not just that we have racked up this astonishing, whatever is $40 or $50 trillion national debt, but the mindset that comes with that kind of deficit financed consumption. And I think that if we can't figure out a way to stop doing that and get a handle on that, I don't see how we come back from that. And then the last thing I would say, we've already touched on it, but just to sum it up, is that in our system, the founders of this country were so genius in their recognition of the fact that a constitution can only ever be a blueprint for government. What matters a lot, and anybody who's ever been involved in a construction project will understand that how the structure actually ends up being built out is guided by the blueprint, but the blueprint never provides an absolutely perfect, representation of the physical object itself. How you build out from that blueprint matters tremendously. And the way in which we build out from the constitutional blueprint is largely through the process of the adjudication of individual cases when there is a dispute between the government and a citizen over the exercise of government power, whether it's the scope of the power and, does the federal government have the power to do this? Does it not? Or the consequences of exercising that power. Should this government official be held liable for violating this person's rights, or should they not? Or a criminal case. Should the government be permitted to put this person in prison or not? In all of those settings, those disputes, and they are incredibly important disputes. It's almost like a coral reef. No one case is going to decide everything about the size and scope of government power. Instead, the size and scope of government power is largely built out and decided in practice by the outcome of hundreds of thousands of individual cases, just like a coral reef. So it matters tremendously how those cases are resolved. And almost without exception, those cases are resolved in a manner that is not prescribed by the Constitution. In almost all of those cases, the outcome should be determined by a bunch of ordinary citizens sitting together as a jury. And in almost none of those cases is that the way those cases are actually determined today. Other than spending ourselves into oblivion, I'm not sure I can think of a bigger disaster of constitutional governance than allowing government employees, whether actual judges in the judicial branch or so-called administrative law judges or other executive branch adjudicators, to be the first line of decision-making when there is a dispute between the government and citizens. That is not the way the system was designed to work. Only a foolish person would do it that way from scratch. And the founders of this country were by no means fools. They understood that the way to adjudicate disputes between the government and citizens is with citizen juries. And that is probably the single greatest hack that the government has achieved of our system. Taking a system that was designed to put ordinary citizens at the heart of the administration of justice and create a system in which they have almost nothing to do with it, which is the system we have today. What a disaster.
Well, thank you very much. I'm going to just have a few concluding words, Clark, but I'll make it very brief. One is I encourage everybody who watches this to consider giving some donation, whether it's even $1 or $5 to these efforts that the Cato and Clark are doing. So please support this work. There are not many people who have this type of commitment, and for people who really share these values, okay, the best way of showing it is according to what your capabilities are. Write a check, okay? Again, even if it's $1 or a single dollar, get yourself involved in any way you're capable of getting involved to help in this battle. The other thing I would like to do and express my appreciation for Clark being here is the first 10 people to write at Johnny, Jonny, at bitchute.com, requesting a copy of Clark's book, Terms of Engagement. I will gift to them. So please write to Johnny, and the first 10 people that write to Johnny, I will be sending either a hard copy or a Kindle copy, whatever people's preferences. But I will gift 10 of books, and I encourage everyone to not only contribute to the Cato, but to read Clark's book. As I said, I read the book. I thought it was a wonderful book, and I would encourage everybody to read it. And I'll contribute by donating it to people who just, all they have to do is just write to Johnny and say, I watched today, and please send me a copy of Clark's book. So thank you so much. I think I really enjoyed this conversation very, very much, and you're really extremely articulate in expressing your point of views, and you express them in a very compelling passion, much more compelling than I did. So I have great appreciation for it. Every time you told me to shut up so that you could say you said things a lot better than I did. So I really appreciate that.
Well, thank you so much. It's been a pleasure, and I can't thank you enough for your kind words about the Cato Institute and the book that I wrote. Any amount of support helps. I can promise everyone that we will put that to good use. And I hope if nobody should feel compelled to read the book, but I hope if you do read it, you'll enjoy it. And feel free to reach out. Let me know what you think.
Thank you so much. Have a great day, Clark.
You too. Thanks, Jeff.
Bye.